I'm going to find sufficient evidence to find you guilty, and at this time find you guilty. I'm going to sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am handing you a trial court certification. Shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Good morning. Are you Isaiah Fuentes? And Mr. Fuentes was previously in court, entered a plea of guilty to the second-degree felony offense of aggravated assault. The agreement in that case was to go on count one only, as well as a 15-year cap. I received a copy of the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, sir.
Yes, Your Honor, we have.
Are there any additions or corrections?
None from the defense.
No corrections from the state judge. I did note, Mr. Lesniak and I discussed his comments that almost clouded this as a self-defense claim, but I think it's more of an explanation than asserting an offense. And we'd ask the court to go forward today.
Okay. Mr. Wilkerson, you may proceed.
All right. I called my client, Mr. Fuentes.
All right, Mr. Fuentes, raise your right hand for me the best you can. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Go ahead.
Mr. Fuentes, when you were asked to provide a description of your version of events in this case, you related to the pre-sentence investigation probation officer that you have been defending yourself. Can you explain to the court just briefly what you meant by that?
That it was two people that charged me up, and they only put in one in my indictment, but it actually was two persons that jumped me.
When
I was
you
just defending myself.
when you say you were just defending yourself, you also have seen a video of what took place in the course of your anger, correct?
Yes.
And you understand and acknowledge to the court that you went past self-defense into the commission of this offense in your actions. Is that correct?
Yes.
And today, are you asking the court to consider your plea in this offense and asking the court for leniency with regard to sentencing?
Yes, sir.
Passed away.
Any questions of the witness?
I have no questions for him, Your Honor.
All right, any other witnesses?
No, Your Honor. I just wanted to briefly explain that that aspect of the pre-sentence investigation, and I would note that that aspect is the singular difference between the instant offense and the other offenses that are listed in Mr. Fuentes' pre-sentence investigation. That this did start out as a situation where Mr. Fuentes kind of walked into it over a female, and then it escalated to what included the instant offense, Your Honor. Mr. Fuentes, while his history, his misdemeanor history, obviously the court's had an opportunity to review the PSI. I would note that 4 of the offenses occurring prior to 2000, the misdemeanor offenses, were related to alcohol, and 2 of them related to driver's license issues. And so while Mr. Fuentes does have a history of offense that involves violence, in this particular instance, that temperament was allowed to take over in his defending himself, but he has pled to the court, and indeed in his PSI he notes that the victim in this case had been deported. And so given his history, he's had advice from any number of lawyers over the course of years, and yet he still entered a plea in this case, knowing that fact as well, Judge. And so we had asked the court for something at the lower end of the sentencing range. If the court were so inclined, The court does have a deferred adjudication option available to it, such that if Mr. Fuentes was to violate, then the full range of punishment would be available to the court if the court would consider putting him on its post-violence caseload, and having the opportunity to demonstrate to the court that he has changed his behavior in the recent years, Judge.
All right, thank you, Mr. Wilkerson. Mr. Nichols?
Judge, this marks his fourth conviction for aggravated assault. On top of having a deadly weapon in penal institution, which was his most recent offense, felony offense. So given that and given the severity of the beating involved in this case, I think 15 is appropriate.
Was this caught on video?
Yes, Your Honor, I have it right here. Would you like to see it?
I would love to see it. I think that would help me, because if it's I think there's, yeah, I need to see it.
I would note that the video only shows one of the individuals involved in this.
Is it very long?
I don't believe so.
No.
Judge, what I'll do is I'll hand the laptop to the court so you can just hit play. I don't know, maybe you can angle it so Mr. Wilkerson can see as well.
You've seen
I've
it.
seen it, yes, and so has my client.
Thank you.
That's a cell phone video taken by somebody at the scene.
Anything else?
Up from stages.
Nothing from the defense.
All right, Mr. Fuentes, at this time, I'm going to find that you entered your plea of guilty freely and voluntarily. Your history and the assaultive part of your history is what gives me the most concern, that this is your third felony aggravated assault. You went to prison for 12 years before for aggravated assault. I think there's 20 misdemeanors, 15 misdemeanors, several assaults there. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty. I'm going to sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am handing you a trial court certification. Shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long it lasts, you can talk to your attorney. Good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor. May I please?
Yes, sir. Thank you, Mr. Wilkerson.